All right, welcome back. This is Registered Trademarks, Part 2, and we are in the textbook at pages 456 to 468. And again, most of what is important was covered in the previous capsule, right? Because, as I said, we're only looking at a very limited number of pages in a very long chapter, so you don't have to really know about the concepts we're looking at in great detail. As long as you have a broad idea, it's good, right? And we looked at most of the concepts to make things simple independently from the cases in the previous capsule, because it's probably the simplest way to learn about them. So here we're going to look at basically what we've already discussed, right, with a few examples and a little bit more detail on some of those sub-issues. The first one is special marks, right? And what are special marks? They're marks that are special, right? And that are very different from what are called ordinary marks, normal trademarks under the Trademarks Act, registered trademarks. So what's a special mark, right? That's defined in Section 2. So Sections 23 to 25 cover the regime applicable to special marks. Section 2 defines it as one that is used to express either the character or quality of the goods or services, the working conditions under which the goods have been produced or the services performed, the class of persons by whom the goods have been produced or the services performed, or the area within which the goods have been produced or the services performed from goods or services that are not of that defined standard, right? And you're given the example of the Fair Trade Labeling Organization, right? So when you buy that, it is a trademark or a mark, because it is something that says something else, right? It's something that is, a description or a set of words that are evocative of something else, right? So here you read fair trade and you are implicitly told that it's been produced under certain conditions that are enumerated somewhere in a much more detailed fashion, and that is policed by the organization, right? That's a good example. And one of the important characteristics of a special mark is that the organization that does the certification cannot be involved in the commercialization of the product, right? Why is that? Well, of course, it wouldn't be fair if the Fair Trade Organization also sold coffee, right? Because, potentially they could skew the standards in a way that would advantage them as a market competitor. And so the whole idea of a special mark is that it's regulated by, another entity that is kind of disinterested or that doesn't have a commercial interest in the thing it's regulating, at least not directly. So Section 9 of the Trademarks Act says you have a monopoly, right? So it says basically once you have a special mark, it cannot be used or it cannot be adopted, right, under the circumstances that are mentioned there. And the requirement under Section 9, right, is that it has to be a public authority. And we'll see what a public authority is, right? We'll see that that's a standard that's a little bit hard to define. But you're told in Section 9 that only a public authority can have a special mark and there has to be notice, right? And that's the only requirement. That's pretty important, right? So it's only really, you apply, and when you meet the conditions as a public authority, you get it. So all the things we said in the previous capsule are irrelevant. So it's very, very broad, right? So it can be descriptive, generally it is, right? It is, bland, right, as we said, right? Fair trade is a bunch of words that you couldn't otherwise trademark because it's too descriptive. So it can be descriptive, It can be misdescriptive, potentially, right? Not sure, what the reason would be, but it could be because that requirement doesn't apply. Doesn't have to be used. And as we saw, use is a requirement both for registration and for continued registration. So you have to show use when you register, but you also can be, removed from the registry if over time someone shows that you're no longer using. Use is not a requirement for a special mark. There's no opposition, right? Basically, it's a dictatorship, right? Once you get it, no one can oppose it. And it's permanent. So we'll see that this system is that you register it basically every 10 years. So a trademark, unlike other types of intellectual property law that we saw, unlike copyright, which we said is limited generally by life of the author plus a couple decades, right? Well, unlike that, a trademark can live forever, subject to, as we said, of course, use and distinctiveness, continued use and distinctiveness, right? But you have to register it every 10 years. You have to renew your registration every 10 years. It's not applicable to a special mark either. So you can have it registered forever without having to file for continuation of registration. And therefore, the special mark is a very, very broad category. And what do you have to illustrate that? Why, right, you have the architect's case. And that's an Ontario organization that essentially regulates a certain type of architect. And they do it the right way, right? They go to the government looks at this, and the government says, you're a public authority, you're good. And the government does the stuff it's supposed to do, right? Publishes it in the Trademark Journal, which is the journals we said that no one reads, but that's supposed to give everyone notice of the fact that you are getting a new trademark, right? And then what happens, right? Someone goes to court and says, this is not legit, right? This was not properly registered. And to go back to the notions that we, that's very nice handwriting there. To go back to the notions that we discussed previously, right, as we said, even though you get notice, so even though, people are told that you're registering something and given generally an opportunity to oppose it. That's not the case for special marks. It's the case for ordinary marks. Even though that is true, that really makes your registration more likely to be legit. So when you go to court, it's harder for someone to say it's not. But it doesn't fully prevent them from contesting it. They can still later on say, this was never legit, you didn't register it properly, you didn't meet the conditions. That's allowed, right? So someone goes to court and says, you cannot get that trademark. And you have, right, this test which is set out. The main issue that we have in the case, right, is essentially this is a regulatory organization, right, like the bar, right? They let people use a title and they regulate that title, right, by setting minimum education requirements, continuing education requirements, and also, quite importantly, by ensuring a standard of quality, right? So if you're being a bad architect, they will, have disciplinary sanctions against you, and they'll prevent you from being an architect. And that also helps, maintain the integrity of the profession and the quality of the services that are rendered by the members, which, of course, has a public benefit. So, who you're trying to protect in the end is ostensibly the public, right? And you have this test from the prior case of Canadian Olympic Association of what it means to be a public authority. So as we said, to register your special mark, you have to be a public authority, right? Well, there's a three-part test, right? So there has to be a duty to the public, right? Then there has to be government control, what they call a significant degree of government control. And three, right? You have to have a benefit to the public. And then they get into this very long digressive discussion as to whether the control thing is actually is still sorry, that was incorrect. They get into a discussion as to whether it's only two requirements or if it is three requirements, right? And the court gets into the application of the test to the architects' society, right? Essentially, the court looks at the criteria and says at paragraph 52 that it sees no reason for departing from the two-part test of government control and government benefit, right? And so the duty thing is not, it's not clear whether it is a requirement or not, right? So it's not clear whether it remains a requirement, likely not, you don't have to worry about that, but essentially it's subsumed into the other one. So these are the main requirements. It has to be government control and a public benefit, and the duty to the public is relevant insofar as it helps prove the other two. So it's not, you know, a requirement of its own, on its own anymore, right? And what happens, this is an appeal, ostensibly of the decision of the registrar to grant the trademark, right? So as we said, when you go out and register your trademark, the government doesn't just rubber stamp what you say. Government looks into it. And who is that? It's the registrar of trademarks, who has the delegated power to do that. And they look into it and they look at whether you meet the criteria, right? And what did the government, the registrar say in that situation? They said yes, because there is government control and there's a public benefit, and therefore, right, we grant your special mark. What does that mean in practice, right? It means we grant you a monopoly over architect. You'll see there's a bunch of terms that they get a monopoly over, and basically they can regulate that. They can say no one can use that term unless we give them, you know, the title, basically. And what did the registrar say, right? The registrar said, well, this whole, you know, architect society is created by statute, right? So there's a statute that creates the organization of architects, right? And there's a bunch of other things that are said in the statute that constitute government control, right? The government can name the board members, for instance, right? But the prior decision maker did not look at these things in great detail. They just said, well, it's created by statute. There's a law that creates the organization, and therefore it is subject to government control because its existence depends on its enabling statute. And if the government repeals it, well, they no longer exist. That's a pretty big level of control. And what does the court say? Well, the court says no, right? That is not correct. You have to actually look at the government control, and it's not sufficient to just assume that there is government control because you have an enabling statute. That is not sufficient, and it was wrong to conclude that there was government control only on that basis. And the court says in paragraph 63 that they have considered this balance that we looked at before. And the balance is between free competition and fair competition or free expression, right? And this balance is particularly relevant here because special marks are broader, right? They prevent more things. They're broader. You can have a monopoly over a descriptive, misdescriptive, unused term, as we said, right? It's pretty big here. You're not just preventing someone from using lint on their chocolate bar. You're preventing someone from using the title architect, which is, ostensibly just a noun in the English language. that you're preventing people from using in some circumstances, right? And the court says the balance is even more important here, right? We have to be restrictive when we give the special mark because it's like a nuclear bomb, because it's more restrictive of what people can subsequently do who are not the trademark owner. And the court said in making our analysis, whatever it is, we have taken into account the importance of this balance, especially as it further tips it, that it's further tipped to the owner of the intellectual property in that specific context. And the court says, right, the court, again, since there's no government control, the court reverses the decision. It's a compound test, control benefit. And if there's no control, it doesn't matter if there's benefit, it's not enough. The court still looks at benefit, right? Because the courts likes to define a test, and under benefit, the court says essentially what I've just said. The court says this is a public benefit because they regulate the whole profession. They ensure a standard of quality. They ensure that architects are good, honest, and don't have the title if they're not. And quite importantly, right, there is kind of a merger of two types of interests here. Essentially, right, there is some private benefit as well, right? The same is true really for lawyers. So the Bar Association is not just looking to protect the public by making sure lawyers are good, right? It has a dual function, at least in most states or provinces, which is to make sure as well that, lawyers are protected, right? So there's an advocacy role. Not, at least not explicitly a role in protecting the legal market for lawyers or in ensuring that lawyers make the most money possible, but an interest in, advocating for the profession. And so the bar might collect some money, and it doesn't use all that money to make sure the public gets access to a lawyer. It also uses that money to make sure the reputation is a good, the profession has a good reputation, which might, involve putting money in on ads or whatever it is, that is not directly related to protecting the public. And the court said, that's fine, right? Court says, that's the nature of these types of organization, and it doesn't really take away from the public benefit. And so you can have a public benefit and a private benefit. As long as there's a predominant or important public benefit, that's fine. And so the fact that the organization, uses its extra money for itself or advocates for the profession doesn't detract from its private benefit. So, as we said, right, we then get to this concept of use, which we discussed in the previous capsule. And as I said, it's pretty important that to remember that the use requirement is a continuing requirement. So you have to use it when you register it. So you don't get a registered trademark in the first place if you're not using it or intending to use it, depending on the specifics. And you have to continually use it. And so, as we said, there's this nice thing called expungement, which is a way where someone can come in and say, hey, this was registered legitimately, but it's no longer used, and it should be removed from the trademark registry because use is a continuing condition of registration for a trademark. And, right, what does it mean to use, right? Well, you have the Apotex case. Obviously, of course, right, use is also what you're reserved as a monopoly owner, right? So you are, by virtue of your commercial monopoly on your trademark, like we said, there's a bunch of commercial monopolies and intellectual property law. You're the only person that can use your trademark, right? And so, as a corollary of that, you can sue people who use it unauthorizedly. So in the Apotex case, right, you're given an example of that. The obvious case, of course, is someone is gonna take your thing to sell their own, right? So they'll take your logo, your packaging, or an imitation of it, and they'll use that to sell their own chocolate bar or whatever it is. Either the same product or a similar product, similar enough, not in an entirely different industry, such that they're building off your good reputation and good name as it would influence a customer to buy their product. And in the Apotex case, right, you have a generic. So essentially, that's under patent law. When you invent a drug, you're protected for a certain period under patent because you've invented it. So that's the requirement under patent. You've invented something and you get a monopoly. So you're the only person that can make and sell that drug for whatever period of time it is. You have a monopoly on the market. You cannot have competitors. And as we said, the reason for that is that we want people to disclose their inventions. We don't want people to be afraid that their invention is going to be stolen in the marketplace and therefore keep it to themselves. And so we give them a monopoly for a period of time, and when that period of time ends, they can get competitors. Usually for drugs, that's pretty important because once people know what the drug is, or the molecule, essentially a drug, right, is a molecule that's going to have an effect on someone. Well, once people know not that the molecule exists, because they know that the molecule exists, but that it has the effect, well, then they can make their own, right, for very cheap because they didn't have to invest millions of dollars into proving it does what it's supposed to do. And so, after the patent expires, very quickly you're going to have a generic, which is someone making the same molecule under a different name and selling it generally for cheaper because they haven't invested into it, right? Well, company does that, right? Company markets its new drug, right? It's generic, and says, look, pharmacists, because in Canada you cannot market to people your drugs, you have to market them to pharmacists, right? Look, pharmacists, this is the same drug for cheaper, right? And a pharmacist is entitled, under the law, we're told, in that province, to basically substitute on their own a drug for the generic on behalf of the patient. So that's why the company is interested in convincing the pharmacist that this is a good, generic that they should substitute. And so, right, what happens, they say, under their brochure, look, this is a generic of the other drug. And the other drug company sues and says, you're using our goodwill, right? Basically, you're using that mention to sell your own drug. It's different from the example that we gave earlier, right? It's different from the typical example where someone is going to be basically passing off their stuff is yours. So saying, look, this is the other drug, right? That's not what the company is doing here. The company is saying, look, this is a generic version of the other drug. And the court essentially says that, right? The court says you're not using the name to sell your own drug, or using the goodwill, the reputation of the drug, or the value of the trademark, which is in that case the name, to sell your own. You're making a comparison to sell something else. And it's clear that it is indeed something else. And for some reason, right, which is actually very complicated, but it's not just in the patent. It's not just as a result of the patent regime. It's also as a result of the food and drugs regulations, right? There's some situations where you can and cannot make a comparison, and in that case, a comparison's allowed, And to the extent that a comparison is allowed, right, that comparison doesn't serve to make the pharmacist think that your drug is the same as the other one. It just serves to make a comparison, right, which is a distinction, right? It's saying it's a generic, but it's also a generic. It's similar, but it's also different. And therefore, you're not really trying to pass off your drug as the other one. You're just, using it to sell your own in an allowed way. And the reason I'm making this much out of the fact that it's allowed is because, of course, in some circumstances, if it were not a drug, it might not be allowed to use someone else's trademark to make a comparison, for instance, on a chocolate bar. So it might not always be allowed with these specific facts but apply to a different product.